Welcome to OGE's discussion on interests of professors. I am Stephanie Nonlisha. The focus of this discussion will be public financial disclosure reports for prospective nominees to presidentially appointed Senate-confirmed positions, TAS nominees. I will be going through the types of interests you are likely to see for individuals who are university professors. I will go over the technical reporting requirements for certain interests, the conflicts issues that arise, and what to include in an ethics agreement. Before you begin your review of a Nominee 278 report, you should be familiar with the 3 OGE guides that are essential to any effective review. First, there is the Public Financial Disclosure Guide, which is an interactive tool to assist in the administration and review of public financial disclosure reports. Second, OGE published a series of guidance documents on analyzing potential conflicts of interest for employment and other financial interests, which includes guidance devoted to employment with institutions of higher education, related research, speaking, and writing activities. Third, OGE recently published an updated Nominee Ethics Agreement Guide that became effective on September 1st, 2020. All of these guides are posted on the OGE website. Now let's quickly review a few of the more common employment interests that a university professor is likely to report in Part 2 of a Nominee 278E. As shown in this example, the reporting of common interests, such as salary and bonus, are pretty straightforward. At lines 1 and 2, the filer reports the exact amount of salary and bonus that he received from the university during the reporting period. The filer also indicates that he is owed a bonus from the university at line 3. Please keep in mind that any anticipated payments from an employer or former employer, such as a bonus, should also be reported as a continuing agreement or arrangement in Part 3 of the 278E. Next, at line 4, the filer reports that he received an honorarium from an association. Honoraria includes payment for speaking, writing an article, or making an appearance. Please note, even if honoraria is donated to a charity or received through a speaker's bureau or a limited liability company, the honoraria must be reported in Part 2. At line 5, the filer reports an honorarium that he anticipates receiving. However, unlike an anticipated bonus, filers are not required to report an anticipated honorarium in Part 3. The filer will report any retirement plans with the university in Parts 2 and 3 of the 278E. Filers from academia typically have defined benefit plans or traditional pension and/or defined contribution plans such as 401k plans, 403b, and 457 plans. I will not go over the basic reporting requirements for retirement plans, but you should consult the 278 guide for information on how to report such interests. A professor's earned income and other benefits may trigger compensation restrictions under the outside earned income ban, which prohibits presidential appointees to full-time non-career positions from receiving any outside earned income during government service. In addition, the Criminal Conflict of Interest Statute 18 U.S.C. Section 209 prohibits supplementation of government salary. Please note that neither of these ethics provisions apply to special government employees or SGEs. 18 U.S.C. Section 209 prohibits an employee from receiving any salary or supplementation of salary from any person other than the United States government as compensation for services as a government employee unless an exception applies. Section 209A permits employees to accept compensation contributed out of the treasury of any state, county, or municipality. Thus, for example, a salary supplementation may fall within this exception as being contributed from the treasury of a state if a state university is bearing the cost. In addition, Section 209B allows an employee to continue to participate in a bona fide pension, retirement, group life, health, or accident insurance, profit sharing, stock bonus, or other employee welfare or benefit plan maintained by a former employer. If an exception does not apply, you will need to perform a 209 analysis for any payments or anything of monetary value that a professor will continue to receive from a university after he enters government service. There is no violation of Section 209 if compensation is paid before the individual becomes a government employee. If the payment will occur before government service, you will need to consider the applicability of the extraordinary payment provision at 5 CFR Section 2635.503. Thus, the timing of any bonus or other payment is important to the 209 or 503 analysis. OGE issued a comprehensive summary of the restriction on supplementation of salary in Legal Advisory DO-02-016. The summary discusses relevant factors to consider when performing a 209 analysis, the various exceptions under Section 209, and the relationship between Section 209 and the gift provisions in the Standards of Ethical Conduct at 5 CFR Part 2635, Subpart B. The 209 summary provides helpful examples of how the statute is applied in different situations. A notable example concerns a university professor on an unpaid leave of absence. Let's take a moment to read that example from the summary. A professor at a university accepts a position with the Office of Personnel Management and is granted an unpaid leave of absence from the university. Absent any other benefits, the unpaid leave status is not a supplementation to his salary because it does not have an ascertainable monetary value. However, under 18 U.S.C. Section 208, he may have to be recused from any particular matter that would have a direct and predictable effect on the financial interests of the university. I will discuss 18 U.S.C. Section 208 in a moment, but let's review the issue of leave of absence as that comes up frequently when dealing with professors. You should ask what the professor plans to do with his position with the university. For a PAS nominee, you will need to check the White House policy on outside positions. Historically, White House policy has required full-time PAS nominees to resign from their outside positions with limited exceptions that must be approved by the White House. Historically, one exception to this policy has permitted a nominee who is a tenured professor to take an unpaid leave of absence with certain caveats. A nominee who is a dean or in another leadership position must resign from that position because dean positions have supervisory and other fiduciary responsibilities that are not conducive to taking a leave of absence. Plus, a university would generally not be inclined to grant the leave of absence for a dean position, which might raise concerns if leave were approved for a person entering federal service. While on leave of absence from an outside employer, a federal employee has an ongoing employment relationship with that outside employer. Accordingly, an employee on a leave of absence is prohibited by 18 U.S.C. Section 208 from participating personally and substantially in any particular matter that the employee knows would directly and predictably affect the financial interests of that outside employer. Two exemptions may be available to employees who are on leaves of absence from an institution of higher education, as defined in 20 U.S.C. Section 1001. The exemption at 5 CFR Section 2640.203B permits the employee to participate in any particular matter of general applicability affecting the financial interests of the institution of higher education from which the employee is on leave, provided that the matter will not have a special or distinct effect on the institution other than as part of a class. For employees who are, 1, employed by a state multi-campus institution of higher education, and 2, their university position has no multi-campus responsibilities, the exemption at 5 CFR, section 2640.203C, permits the employee to participate in any particular matter affecting a different campus of the institution. You can find examples for these exemptions in the text of the regulation. If the nominee plans to take an unpaid leave of absence, you should ask about the terms of the leave of absence and whether the nominee will receive any continuing benefits from the university while on leave. If a nominee on a leave of absence from an institution of higher education will receive certain benefits and privileges from the institution, such as a housing allowance, discounted tuition, or mortgage subsidy, you should evaluate these continuing benefits under 18 U.S.C. Section 209. For example, does the university have a written policy on the terms of the unpaid leave of absence, and will the nominee be taking a leave of absence in accordance with university policy or established past practice? Or is the university making an exception for the nominee? If an exception is being made, you will need to analyze that exception under 18 U.S.C. Section 209. What is the length of the unpaid leave of absence? Typically, a leave of absence is granted for 1 to 2 years. Some do not have an exact time limit. For instance, the leave of absence may be granted for the term of appointment. What is the possibility that the unpaid leave of absence will be extended, and is there established criteria for extending the unpaid leave of absence beyond the specified time? For example, does the university grant extensions to individuals other than those who enter federal government service? Also, if the leave is extended, will any benefits be extended along with the unpaid leave of absence? Our primary concern with leave of absence is not so much the extension of time. We're more concerned with the fringe benefits that may come with it because the benefits have monetary value, which makes any exception to university policy susceptible to a possible 209 concern. Make sure that if the nominee receives any continuing benefits, that they are pursuant to standard terms. Finally, make sure the nominee gets the unpaid leave of absence approved by the White House and the university as early in the pre-clearance process as possible. You don't want a situation where the nominee gets far along in the process only to find out later the university or White House will not approve the request. Any arrangement for an unpaid leave of absence must be reported in Part 3 of the 278E as shown in this example, where the filer has described the unpaid leave of absence and its terms. The filer has also indicated that he will keep his retirement plan with the university, but no contributions will be made by the university during the leave of absence. In addition, you'll see the filer has also reported his anticipated bonus and its terms in this part. You may recall that this anticipated bonus was previously reported in Part 2. In certain cases, a nominee on a leave of absence from a university may be eligible to receive certain benefits and privileges from the university, such as health insurance, life insurance, housing allowance, discounted tuition, mortgage subsidy, etc. You should analyze the terms of these benefits to ensure any benefit that a nominee receives is not being given or enhanced because the person is coming into the federal government. A nominee may be able to accept these benefits upon a determination by the agency that the benefits do not violate 18 U.S.C. Section 209 or the gift provisions of the Standards of Conduct. Many of the benefits available to employees on a leave of absence qualify for the exception at Section 209B, which allows continued participation if the benefits are bona fide pension, retirement, group life, health, or accident insurance, or other employee welfare or benefit plans maintained by the former employer. An employee may also accept other types of benefits and privileges from the university, such as a housing allowance or discounted tuition, so long as the benefits are not given with the intent of supplementing the employee's salary in violation of 18 U.S.C. Section 209. For example, when comparable benefits are available to other persons on leave of absence who are not going to the federal government, it is unlikely that the benefit is compensation for government service, and Section 209 is therefore unlikely to apply. The use of office space, research assistants, and research facilities would be problematic because it would call into question whether the nominee is really on a leave of absence. Next, ask if the nominee plans to continue teaching. Under the outside earned income ban, a full-time PAS will not be able to continue teaching for pay, even if he is no longer employed by the university or while on a leave of absence. You should also confirm that the nominee will be able to stop teaching even if he is confirmed mid-semester. Make sure the nominee understands that he cannot provide any services while on an unpaid leave of absence. That means he cannot hold office hours or mentor students. You should ask whether the nominee has any future speaking engagements planned. Again, full-time PAS employees are subject to the outside earned income ban, so they would have to forego any compensation for any future speaking engagements. Also, under Section 209, the nominee cannot accept compensation from any source other than the U.S. government for services as a government employee. So you should counsel nominees that after appointment, they cannot be paid by anyone other than the government for making speeches or appearances that is undertaken as part of their official duties. In addition, the Standards of Conduct regulation for teaching, speaking, and writing at Section 807 prohibits an employee from receiving compensation, including travel expenses, from an outside source for speaking that relates to the employee's official duties. More on Section 807 in a moment. You should ask, does the nominee have any book deals, advances, or book royalties? Full-time PAS employees will not be able to get paid to write a book while they are a government employee or update a book during their government service because of the outside earned income ban. Therefore, a nominee who has received an advance prior to entering the government cannot work on the book while an employee, or he'd have to forego the advance. Even if the nominee did not and will not receive an advance, royalties could be a concern under 5 CFR 2635.807. Section 807 prohibits an employee from receiving any compensation for writing that is related to an employee's official duties. You should consult with OGE if the nominee wants to write while in government. OGE has issued detailed legal advisories on analyzing book deals. In 2008, OGE issued advisory DO-08-006 and its attachments 006A and 006B that contains detailed analysis and interpretation of all relevant provisions of the ethics laws and regulations affecting whether or not an employee may accept compensation for writing a book. The advisory contains 2 parts. 006A addresses regular government employees and FTEs. 006B addresses covered non-career employees and full-time presidential appointees. In September 2020, OGE issued legal advisory LA-20-06, supplementing the 2008 advisory by providing guidance on additional book deal issues relevant to incoming and outgoing employees. Professors may have other intellectual property, such as patents or inventions or IPs. IPs can be very complicated, so you should consult with OGE if you see IPs on a report. Intellectual property rights in books, copyrights, trademarks, or other similar creative or artistic projects are reported in Part 2 of the 278E. Here is an example of how to report IPs from the 278 guide. The filer reports intellectual property if the value was more than $1,000 at the end of the reporting period, or if the intellectual property produced more than $200 in income during the reporting period. The filer should describe the intellectual property. For a book, provide the name of the book and identify the publisher. For a patent, provide the patent number and a very brief description of the patent. For other types of intellectual property, provide a similarly specific description that is sufficient for the reader to understand the nature of the property. If the IP is shared with the university through a licensing, royalty sharing program, or other similar arrangement, then it will also need to be reported as an arrangement in Part 3 of the 278E. For the conflict analysis, if the nominee is getting royalties, he will be subject to an ability or willingness recusal under 18 U.S.C. Section 208 to the publisher. This means that the nominee cannot work on any particular matter that would have a direct and predictable effect on the ability or willingness of the publisher to pay him under the terms of the contract. This is very unlikely to be a problem because it means that the nominee cannot work on a particular matter that could put the publisher out of business. The nominee has a full 208 recusal concerning personal and substantial participation in any particular government matter that would have a direct and predictable effect on the sales of his book. For example, employees should not direct their staff to buy their book or have their agency purchase copies of their book. Under 5 CFR, Section 2635.502, the nominee has a covered relationship with his publisher, which means that he cannot participate personally and substantially in any particular matter involving specific parties in which the publisher is a party or represents a party. It is unlikely that an employee would be asked to work on such a party matter, but that needs to be analyzed on a case-by-case basis. Other ethics issues under the standards of conduct that the agency should counsel the nominee on include use of official title, use of government time and equipment, etc. After the 278E and conflict analysis is complete, you can draft the ethics agreement. As the ethics official, you will prepare an EA outlining the steps the nominee will take to avoid conflicts of interest using the EA guide. The following sample language from the EA guide is for a situation in which a PAS nominee has an arrangement with a publisher to write a textbook, but the PAS nominee has agreed not to work on the textbook during his appointment. It includes information about the advance, identity of the publisher, and a 502 recusal for the publisher. The EA guide also includes sample language for an arrangement with a publisher for book royalties, as shown in this example. Again, it includes information about the royalties, identity of the publisher, and a 502 recusal for the publisher. As I previously mentioned, the nominee will have a Section 208 ability or willingness recusal to the publisher. However, the likelihood a nominee would participate in a particular matter that would affect the publisher's ability or willingness to pay the terms of a book contract is extremely remote. So we did not include the 208 ability or willingness recusal in the sample EA language. We include a 502 recusal statement because the potential for an appearance of a conflict of interest is more likely. I want to point out that there is also language in the EA guide for the 208 regulatory exemptions for leave of absence from a university, as well as sample language for a recusal for interest in patents. In concluding this discussion, please remember that nominees must fully disclose their interests in order for you, the ethics official, to be able to effectively counsel them on ethics rules and restrictions that apply to them. Interests of professors is a complicated area of financial disclosure and conflicts analysis, so you should consult OGE's various guidance documents as needed and contact OGE for additional assistance. Thank you.